All right, so let's talk about what happens after that. So if the court, whenever they agree to grant cert, that is an order to the lower court to send all the records. So all of the court data, all of the information, all of the records, etc., that is going to be sent to the Supreme Court, and they're going to schedule a date. In between that, the date and the date of oral arguments, the clerks will continue to look at the evidence, look at the research. That would be Bree's phone going off. Okay. They're going to look at evidence, they're going to look at all the research, etc., and they're going to schedule a date for oral arguments. Okay? Unless you each side gets 30 minutes. That's it. So one of the coolest things I ever got to do is I did, when I went to Washington, D.C. one time, I did get to sit and go hear the Supreme Court and like sit in on a case. It's public.
You can do that?
It was like my Super Bowl. Like, it was the coolest thing ever. I was really I felt so small. Anyway, okay. So there's only room for a couple hundred people. There's no press in the room. I mean, if there's press in there, but there's no electronic press, so they don't record. There's no cameras. They can just be in there listening. The justices kind of sit up at the front of the rooms, and then the attorneys, basically they get 30 minutes to argue in front of the court. I will tell you that the justices typically interrupt the attorney a lot. So, if Bree was the attorney, they're up there and they just kind of interrupt you and they ask questions all the time. It depends on the justice, and their style. So, Justice Breyer talks with his hands all the time and he's constantly asking questions. Justice Thomas sits there very quietly and rocks back and forth. So they all kind of have a different view of oral argument. Our current Chief Justice is John Roberts, so I was going to show you just a little clip of him talking about his perspective on oral argument and what it's for.
Do you remember your first oral argument?
Oh, sure. Yes. Absolutely.
He is.
It's called the States against Halper. I was very nervous. I was very nervous when I did my last oral argument as well. I think if you're a lawyer appearing before the Supreme Court and you're not very nervous, you don't really understand what's going on.
And this is a question for all the members of the bar out there, I guess, and for all those attorneys who eventually find themselves lucky enough to have a case before the court. What is it that you wish you had known about the process when you were on that side that you now know?
Everybody tells a lawyer in that position, you have to answer the questions. Don't try to avoid the questions or distinguish your case in any way. I hope I did that when I was a lawyer, but the importance of that is very accentuated. I appreciate it so much more now that I'm on the other side of the bench. You have to appreciate that the justices are engaged in the process of trying to help themselves decide the case correctly. So they're going to ask hard questions. They're going to ask questions that don't put your case in the best possible light, and you need to appreciate that. It's good to establish, I think I didn't appreciate this as much as I should have, some dispassion. Yes, you want to have a certain level of zeal and commitment to your client's cause. The justices know that. But when they ask you a question about a difficult case, it's better to sometimes say, I appreciate that case doesn't support my side. I appreciate that causes us some difficulty. Here's why I think you shouldn't rely so heavily on that case, as opposed to as soon as they ask us, no, that case doesn't hurt us at all, and here's why. They like you to be part of the process that is helping them come to the right result. They understand you've got a client to represent, and they expect you to do that. But if you can convince them that you're on their side in helping them reach the right decision, as opposed to something they have to push against to get you to give an answer, I think that's very helpful. Not only to the court, but also to your client.
So, I think it's, I really like his presentation there, because you have to consider, the oral argument is just an opportunity to delve into things that maybe weren't in the case briefs, or things that they want to ask extra questions about. After oral arguments, then the justices basically have time to decide. It could take months before they ultimately issue a decision, unless it's a really high profile, we need a decision right now, like a Bush versus Gore kind of case. Sometimes it could be several months down the line. So usually towards the end of the summer, they'll issue several decisions. And there are 3 different kind of decisions that we can get. A majority decision is just whoever won. And there's 9 justices. They don't all always participate if they have some kind of conflict based on their personal lives or their previous jobs, and they might not. Like the one time I was there, Justice Scalia had to remove himself from a case because he had a financial tie to one of the parties involved in the case. So it's just whoever the winners are. If the Chief Justice is in the majority, then he or she does have a right to write the decision if they so choose. And the decision is what's important. It's not even the vote is important, because the decision is where we get the precedent and we get the legal reasoning. Think about all those phrases that you've learned about separate but equal, or like all of those phrases that you learn in U.S. history, the precedents, that's where we get them. And so understanding those decisions is obviously very, very important. You can also have a concurring opinion. A concurring agrees with the decision, but they have different legal reasoning for it. So, for example, Justice Roberts could write a majority opinion. Justice Scalia might agree with it, and so they'll also sign their name to that majority opinion. But then Scalia could also write a concurrence, which says, I have some other points that I want to make. I agree with your decision, but there's some things that you didn't put in your opinion that I want to make sure you understand as well.
So are they writing out, full out,
Yeah, I mean, they're long. I mean, some of the decisions could be as long as 50, 60 pages, depending on how many decisions you have, because you could theoretically have 9 opinions written on a case. When Justice Roberts took over as Chief Justice, he said he wanted to have a lot of 9-0, really establish the principle kind of decisions. They have had very little of that. They've had a lot of 5-4 decisions. And we're going to look at kind of that next class. A dissenting opinion is what it sounds like. It says, you're wrong, and here's why. So interestingly enough, dissenting opinions can be really powerful, because sometimes the court will change their mind. And so sometimes the dissenting opinion years later can turn around and represent what the majority wants, 15, 20 years later. There are also sometimes really important quotes or arguments that we take from the dissenting opinion. But the precedent is established by the majority opinion, though the concurring opinion can also help to do that. Sometimes it can provide some kind of illumination. Remember last unit when I had you look at those 3 Supreme Court cases about presidential power, the one about the President Truman, the steel mills? Actually the most important decision in that case was the concurrence, because it was better written and it gave a lot of clarity and a lot of direction to the presidential power. And so most people today historically look at the concurrence rather than the majority opinion. Okay? We also have this concept called stare decisis and per curiam decisions, but based on the fact that you guys are packing up, I guess it means that class is over. So we will pick up there next class.